Okay, good morning. In this case, the court's asked to decide whether a school district's practice of exclusively targeting commercial properties for tax assessment appeals violates the uniformity clause of our state constitution.
May it please the court, my name is John Summers and I represent the appellant taxpayers Morgan Property, Abrams Run, and KBF Associates. This case presents the question of first impression of whether a school district's practice of taking property assessment appeals that discriminate against commercial or large value properties violates the uniformity clause. This is an enormously important case, not just to the litigants, but as demonstrated by the unusually large number of amici briefs, 13. This is an issue of great importance throughout the Commonwealth. There are two applicable uniformity clause, Article 8, Section 1, principles that I think we all can agree upon. The first, as this court showed just 6 months ago, the Mount Airy opinion, the court reaffirmed century-old precedent that the uniformity clause prohibits a taxing authority from opposing a variable rate tax. That is, setting a higher effective tax rate on more valuable property than less valuable property. And that was not in a property context, but in an excise context. The second principle I think we can all agree upon is that in the context of property taxation, as this court held in Clifton in 2009, it, in that case, again reaffirmed a century-old precedent holding that some classes of property may not be assessed at higher rates than other classes of property. As Justice Weck's opinion in the Mount Airy case demonstrated, an animating principle under all of the uniformity clause jurisprudence is that in 1874, when the uniformity clause was adopted, it was designed to stop inequitable fiscal properties that resulted from parliamentary favoritism. That's what this case is about. Now, this case is a case of first impression in that it involves an act of favoritism through a taxing authority, a school district, exercising its appeal powers. But in all other respects, the law is clear in prohibiting this conduct. So here's what the school district is doing, and since this case is before this court on the grant of a demur, the allegations of the complaint need to be taken as true.
May I ask, counsel, is it your position that 8855 is unconstitutional?
No.
And doesn't that statute say that the district can appeal an assessment just like an individual taxpayer can?
Close. What it does is it provides a right of appeal to a taxing authority, period. But it does not shield and cloak a township, a school district, a county from exercising that appeal in an unconstitutional manner. And that's precisely what's happening here. What is happening here is that the school district is exercising its discretion on what to appeal and not what to appeal, and it is deliberately focusing on higher value in commercial properties and not appealing any of the single-family dwelling homes that are owned by local taxpayers. And it's extraordinary. In the Upper Merion School District, there are 9,855 single-family homes, and 80.6 of them are under-assessed. Not one has been appealed, yet properties like the taxpayers have.
Then why should you not have brought the Clifton-like action to reassess the entire district instead of saying our clients have a constitutional right to be under-assessed?
Look, a Clifton remedy of ordering a countywide reassessment is a broad and extreme measure that requires certain kinds of underlying factual foundations. Studies need to be done about overall coefficients of dispersion. That's a remedy that's broad and has a broad impact. Here, we sought to bring a more narrowly focused claim, which is an equitable claim seeking an injunction saying, school district, you can't cherry pick, you can't discriminate, you can't use this device of appeals as a revenue enhancer, as the amici's briefs so readily demonstrate.
But isn't the result of your argument that the entire district, on your assertion, 85% of the residential homes, and of course your clients, are improperly assessed, and that we should, as a matter of law, reaffirm that there's some constitutional right to be improperly assessed, which is the inverse of Clifton, where we said there's a constitutional right to have proper assessments. That what's bothersome, aside from, there's a lot that's bothersome here. Standing is bothersome. But what's bothersome is at the bottom line, your clients say that the uniformity clause protects them from a proper assessment.
I think our claim, Your Honor, is far more modest than that. Our claim is the following. Our claim is the uniformity clause imposes obligations to treat properties uniform, particularly in the context of property. There's a very, very high, near per se prohibition against distinctions. And that our clients, as commercial property owners, shouldn't be treated any differently from residential property owners. In that sense, it's far more modest. We are not asking this court to step in and disrupt what may be everything that's going on in the school district or the county to change all the assessments everywhere. It's a far more narrow and modest effort than that. And a countywide reassessment and requiring and urging a countywide reassessment, first of all, we're challenging a school district, which is only one part of the entire county.
But if you don't want to, if I could follow up on that question, counsel, if you don't want to argue that 8855 is unconstitutional, doesn't that statute give them that right to cherry pick? I mean, if they get to appeal for reassessment individual properties like individual owners, isn't that legislative sanctioning, legislative approval of the very cherry picking you're complaining of?
No, respectfully, Your Honor, for a couple of reasons. First of all, that section of the code is a legislative act. It is lower than the Constitution in the hierarchy of the laws of this Commonwealth. And so that an interpretation and implementation of a statutory right does not excuse unconstitutional conduct. The uniformity clause governs the school district. That argument, if accepted, would suggest that the General Assembly has immunized the school district from compliance with the uniformity clause, and that it clearly has not. There's no basis for concluding that a legislature can excuse a taxing authority from compliance with a constitutional provision. And second, Your Honor, if I may, the leading commentators, Joseph Bright, Burt Goodman, whose treatises Your Honors have cited, have pointed specifically to this kind of conduct as inappropriate. They have said that what's really going on here is this practice is akin to a kind of spot assessing. It's not spot assessing in the literal way in which the statute is written, because this is a taxing authority that is not setting the assessment. It's not a Board of Assessment Appeals, and the statute is designed to that. But this is what the school district is doing, is it's acting indirectly rather than directly. And that has a uniformity clause component, because the cherry picking that's going on here is not cherry picking that is part of a countywide reassessment. It's because on an ad hoc basis, there's a judgment by a school district, hey, we can make some more revenue because we think that property is out of whack. And they're looking at the properties and selecting the properties, not by saying which properties are most out of whack, most not in compliance with a countywide reassessment, but rather they're looking at, hey, let's go after the big tickets, the commercial properties, the apartment complexes. And that this court has absolutely prohibited in Clifton and its progeny. The school district attempts to justify its conduct by saying that the test to be measured for its conduct is a rational relation test. That simply is not the case. What the school district and the Commonwealth Court has done has said, well, in the Downingtown case, there was some language, and we're going to seize on that language to create a rational relation test. In particular, the language from Chief Justice Saylor, your opinion, was, we do not find that this general uniformity precept eliminates any opportunity or need to consider meaningful subclassifications as a component of the overall evaluation of uniform treatment. That's at page 200 of Your Honor's opinion. Well, the school district and the Commonwealth Court would lead one to believe that that applies to the review of a taxing authority's discretion. In fact, what that language did was it was a direction to a trial court that you are permitted to review evidence of meaningful subclassifications in figuring out what somebody's assessment should be. It has nothing to do with a test with respect to what a taxing authority can and cannot do. And it's completely inconsistent with Clifton in the direction of Clifton and all the other courts that prohibit this kind of deferential review. Moreover, a second fundamental component of the defense of the school district here is they say, we've got a legitimate interest. We want to raise revenue. And so it's okay to go after the big ticket items. I think, as Mount Airy has put to bed that notion, because as was described in Mount Airy, simply a desire to increase revenue, which is always the case in every move, presumably by any taxing authority.
But counsel, they as already said, interesting case. They could have said, look, we're very business friendly. We're going after all residences worth $500,000 or more. I think you have those in Lower Merion. And they would have then had the same argument. Don't bother us, go after the businesses, or go after the residential houses worth less than $500,000. So if we affirm your argument, if we buy it, don't we provide a defense against all taxing authority appeals on the grounds that go bother someone else?
I think there are two basic responses to that, Judge Baer. The first is, I think if this cherry picking stops, what in practical matter the court would be doing is it would be saying, hey, this is Montgomery County at the moment. There's not been a countywide reassessment for 20 years. You've got properties all over. It empowers, frankly, the school districts to use the local political process and say, hey, we need a countywide reassessment. And, you know, this Commonwealth is a bit of an outlier across other jurisdictions. Many, many other states require far, far more frequent countywide reassessments. But I'm not here to fight the battle that says we're asking you.
Clifton, but I lost that fight.
So I think that's the first point, Your Honor. The second point, Your Honor, is that what we're really about is stopping at the short run conduct that is discriminatory. The school district, if it wants to bring appeals, it can do that. We've got no problem with the school district bringing appeals, and it can exercise its authority. It can't do it in a discriminatory way.
We're not bringing
and that's
appeals.
not hard.
We're not bringing appeals.
Or not.
Your case is at base a constitutional claim that there's a disparate, unconstitutional treatment of taxpayers, period. And that's not permitted by our Constitution. Is that correct?
Yes. And that the cure to that could be that the school district could take proportionate appeals. I looked at the assessment base for Upper Merion School District. According to a 2015 filing with STEB, there's about $3.5 billion worth of assessments. About $1.5 billion is residential, 43%, and $1.7 billion is commercial. That's 48%. The cure here is easy. If they want to bring appeals, they can bring in efficiency considerations to decide whether to appeal, how much to appeal, but if you're going to appeal, you can't do it in a discriminatory way.
Well, how is that assessed except on a case-by-case basis? I mean, can't this be litigated on a case-by-case basis administratively? I mean, it seems to me, pushed to its limit, your argument nullifies 8855, which you do not contend is unconstitutional, and you're not arguing for a Clifton situation. I don't know how your argument is vindicated in the presence of the legislative mandate expressed in 8855.
I'll try for my third time, Your Honor.
It's my infirmity, not yours.
No. I obviously haven't adequately explained. Look, 35, that section 8855, it's not unqualified. The school district couldn't say we're going to appeal African American homes and not others. It's not an absolute right, and the reason is because you read into that section, not that it's unconstitutional, it's just that as applied, it can't be unconstitutionally implemented. Just as you can't discriminate in all kinds of ways. And it's really a very small, modest request in that respect, and it's a modest interpretation. We are not seeking a finding that there's an overall unconstitutional General Assembly act. It's just that when you act, you have to act in a constitutional way.
Thank you. Does that pretty well conclude your argument? I mean, we understand that we understand your argument is it is what it is.
Don't make the mistake of pausing, because that's when the chief steps in and stops you.
Let me, if I may, conclude with one final note. This case is not just important because of the possibility, the probability, the actuality of unconstitutional conduct, but as the amicus briefs make clear, particularly the distinguished economists who submitted a brief, this is not simply about whether you tax rich commercial owners as compared to helping school children. Of course, we all want to help school children. But what happens here is, if you allow this in the context of apartment complexes, you tax the apartment complexes, and as the apartment complex amicus brief says, that tax gets passed on in not necessarily an obvious way to senior citizens who are on fixed incomes, to young families who are renters. It works inefficiencies in the allocation of capital and investments. It detrimentally impacts labor and wages in this district. This has a major impact on the economies of the Commonwealth, and it's detrimental. And for that reason, we respectfully ask that Your Honor reverse the POs and let us have a trial. Thank you.
Thank you.
May it please the Court, Wendy Rothstein, Fox Rothschild, on behalf of Upper Merion Area School District. I stand here today not just on behalf of Upper Merion, but on behalf of the 14 other school districts that filed amicus briefs and the 500 school districts across the Commonwealth of Pennsylvania that are represented by the Pennsylvania School Board Association that also filed an amicus brief. I'm here today to defend not just public education, but the funding stream for public education in the Commonwealth of Pennsylvania. As Judge Wecht had indicated, Section 8855 provides the school district not an unfettered right, but a right, like taxpayers, to appeal assessments. That right is under attack here, and it's important to note—
Or you exercise, just so we're clear, you're not— is there any dispute? Are you exercising this right only against commercial properties?
Well, we're here in the context of preliminary objections, so we have to take as true what they say.
Yeah.
I don't know that the facts are that, but we have to— but what it is, Your Honor, is they're saying that there are underassessed properties that we're not appealing, and there are underassessed properties that we are appealing. So I would submit the classifications not commercial versus residential, but some underassessed properties that we've chosen not to appeal and some underassessed properties that we've chosen to appeal. They're saying in there that they're residential versus commercial.
What would be the rationale for appealing some underassessed properties and not others?
Good question, Your Honor. I've been doing this for 34 years, representing school district as solicitors involving tax assessment appeal cases. And there's 5 or 6 times that school districts, and more importantly, the solicitors, are making recommendations to school districts. How does that work? First is whether to recommend to a school board to appeal a property. That's the first one. The second one is when taxpayers appeal and they go to the Board of Assessment, a school district, and more importantly, their solicitors, making a decision, should we go attend that hearing and should we defend the appeal? We don't appeal every property. We don't go and defend every appeal. Third is that when a Board of Assessment lowers an assessment, a school district and their solicitors making a recommendation is making a decision whether to appeal that lowering of the assessment. Not every assessment that's lowered by a Board of Assessment is appealed to court. The fourth is when there is a case in the Court of Common Pleas, decisions are made every day. As every other litigation that happens, 90% of them get settled before you go to trial. So a decision is made at that point. Again, another discretionary decision. Which cases do we settle? And what is the amount of the settlement? If you have a small property, most likely the compromise is going to be a lot less than when you have a larger property.
That all makes sense, but let me ask you, accepting for the purposes of argument, that the school district in this case, in this county, only appeals assessments of commercial properties and not residential properties. Is that constitutional?
I believe it is, Your Honor, for a number of reasons. First, and we've raised in a motion to quash this appeal that this is a uniformity argument that has been brought by the taxpayer. This court, and Your Honor, in Downingtown, said that the uniformity arguments are alive and well, that STEB did not eliminate uniformity arguments, and the case law talks about with uniformity arguments, if you prove that the ratio generally applied in the district is lower than the common level ratio, then you get that ratio applied to your property. They have raised that in the Court of Common Pleas. The 2 appellants that are still left in the case have pending cases in the Court of Common Pleas. The other 3 compromised and settled the cases with the school district. The 2 that are pending the cases are still pending. They can litigate the uniformity in those cases because they've raised it in new matter. We raised preliminary objections that they failed.
Ms. Rothstein, I apologize. Just go back for 2 seconds.
Sure.
What's pending in the trial court?
The assessment appeals. The appeals that were filed by the school district, those appeals are pending. A trial will be coming up. They've raised the same constitutional uniformity arguments in those 2 cases that they've raised here in a separate equity lawsuit. The relief they asked for is the wrong relief. If you prove a uniformity violation, and they say it in their complaint, that they generally aver that there is a different ratio that is applied to residential properties than to commercial properties. They say they have a report. They don't give us what that ratio is or that rate. In the Court of Common Pleas, they can litigate it, and this court never has to get this decision.
That's a different issue. That's a different issue. I mean, this is a different case, than, as I understand it. I mean, what they're complaining about is they, as commercial property owners, are the only entities that are put through this process you just described. Forget about the ratios. I mean, their argument is it should not only be commercial property owners who go through the appeals process, some ending in settlement. It doesn't matter. I mean, their argument, as I understand it, is if you're going to do that, you have to do it proportionally to the commercial property owners and the residential property owners. I think what you're talking about is a different issue that's pending.
Actually, that may have morphed through their briefs. If you go back to their complaint is a standard uniformity, and that you don't see the word discriminatory or anywhere in their complaint. I submit that they've kind of morphed two arguments together as this case has proceeded. It's a standard uniformity argument that they argue that 80% of the residential properties have a ratio which is lower than the common level ratio than the property that we appealed. I submit this is a standard uniformity case, and they've tried to somehow create it into a hybrid that it's not. They don't talk about discrimination or anything.
Well, you don't need discrimination. You have disparate treatment of similarly situated taxpayers. And the only question that I'm probing is, can that withstand constitutional scrutiny?
I think if we have a legitimate governmental purpose for it, otherwise, Your Honor, the result is that we have to go out and we have to value every property, and if every property is underassessed under their argument, we have to appeal all of them.
I don't know what the relief is or the remedy, but let's first see if there's a constitutional violation. And that's just, I'm speaking for myself. But it just seems to me troublesome if you, for purposes of preliminary objections, treat taxpayers different within the same jurisdiction. That seems to me the essence of uniformity. You're entitled to equal treatment. What that is, and then you don't need to use the terms discrimination. It's a uniformity. You treat all the taxpayers the same.
Well, again, Your Honor, all the uniformity cases talk about they're entitled to not a lower ratio, not a higher ratio, the same ratio.
We're talking about appeals. You're targeting, according to the complaint, commercial properties for appeal, and you're ignoring residential properties. It can't be any simpler than that. But maybe I'm missing something.
Well, you have a couple things, Your Honor. You have a procedural flaw here that we raised the failure to exhaust. The lower court granted the preliminary objections in part for that. The Commonwealth Court affirmed that, and that has not been brought up to this court. They're bound by that decision. They've waived it. They could have raised it three ways in their petition. They could have raised it in their questions presented. They could have raised it in their brief. They didn't raise it anywhere. That is a decision of a court of this Commonwealth of Pennsylvania that they're bound by. How do they get around that when there's a court that said you needed to litigate this through the assessment appeal process and you didn't?
Can I interrupt for a moment?
Yes.
We granted allowance of appeal on the issue that the Chief Justice has presented in the question that I asked you. So whether or not you think that it's something that has to be gotten around, we've granted aliquotter on the issue of whether or not there is a lack of uniformity in the manner in which the appeals are being taken. So
how does this court get around the fact you had another decision made by the lower court and the Commonwealth Court that they failed to exhaust and they had an adequate remedy and they need to pursue that? And if they do pursue it, this court's not supposed to give advisory opinions. If they do pursue it, who's not to say that the Court of Common Pleas may grant their argument and stay the appeal?
The nice thing about being in the court is we can get around what we want. So assume they have standing, even though you'll go to your grave disagreeing. Don't bother us with standing right now, okay? And therefore, focus in, because this is your only chance and it's waning. Focus in on the constitutionality. The definition of uniformity is if you divide anything taxable into different classes. The argument that the Chief Justice poses, Justice Donoghue poses, where the opponent poses is you've got two classes here. And that is equal protection, and equal protection is uniformity to at least some extent. And the question, therefore, is whether you want to apply the Equal Protection Clause, whether you want to apply the Uniformity Clause, unless you think there's a different legal criteria that you want us to assess, why aren't your two classes unconstitutional? Well, I think that's the case.
As the court said, this is not an attack on the face. So it's not a Mount Airy case where there you had two different rates. You don't have different rates here. So this is, if it's an attack at all, it's an attack on the statute as applied. And this court...
Well, do you have two different classes here?
Right, and this court...
I'm asking you.
Well, I don't believe we do. And if we do, I don't believe it's commercial versus residential. I believe it's properties that we've chosen, under-assessed properties that we've chosen to appeal versus under-assessed properties that we haven't.
In your selection of the properties being assessed, is it fair to say that you were directed as to the type of properties as a result of the Keystone company that you retained?
Yes, they make recommendations, and those recommendations, along with a review by the solicitor, is what happens.
And it's fair to say that those recommendations, they retained a contingent fee from the monies that you would recoup, correct?
Yes.
Thank you.
Isn't that, at least arguably, for PO purposes, enough to get them the opportunity to develop a record on their assertion that there's a greater effective tax rate created by the consulting arrangement Justice Dougherty raised?
I don't think it is, Your Honor. When you go back and again you look at the complaint and you look at what they plead and the relief they ask for, one, they ask for class action relief when it's not a class action case. They're asking not just for relief regarding their appeals, regarding their properties. They're asking for a blanket injunction enjoining the school district from any appeals. And they're also asking for a blanket injunction regarding accepting any recommendations from the consulting firm. I think on the face of the complaint, you don't need to look farther than the complaint as to what they've pled and what they've asked for and the type of relief they asked for. That's not the type of relief that they're able to recover. But to go back to one of the other questions, Clifton, in the two-part test, assumes that there is a classification, and it's not the appellant here seems to want to argue that it's a per se strict liability, that once you prove a classification, we're done, and it's a uniformity violation. Well, Clifton, by its own wording, says otherwise, because it's a two-part test, and the first part is if there's a classification. The second part is it's only if it's unreasonable and not rationally related to any legitimate state purpose.
Uniformity can demand more than equal protection, can't it?
Yes. But again, the test that this court has set forth allows a court to look at, and is there a rational basis for the decision of the school district? And in this instance, you know, the Commonwealth Court in multiple cases has talked about the judicious use of school district and public funds, that if you appeal, if I have 1,000 residential properties that are underassessed by 10%, or I have 2 commercial properties that are underassessed by 10%, it's 1,000 appeals I'm filing with filing costs. It's 1,000 appraisal reports. It's 1,000 trials as compared to 2 appeals and 2 appraisal reports and 2 trials. Unless this court is going to rule that we have to appeal every underassessed property, otherwise you're gutting 8855. And as I started in the beginning, throughout we're making decisions. Is now someone going to overlook my shoulder when I decide with a certain appeal they're going to look at it? Well, you did a compromise and you gave them a 10% reduction with the residential, but only a 5% reduction in the commercial? Are you going to look over our shoulder when I decide we're not going to appeal to the Commonwealth Court?
What we're going to do is decide this case. And it's a good place to end, which is back where you began, as you said. So if you have a word or two by summation.
In summary, with all due respect, Your Honor, the fact that you accepted it doesn't get around the fact that they failed to exhaust their administrative remedies, and this court needs to look at that. 2, the district is making decisions because it would be impossible to appeal everything. And if you're going to find on behalf of the taxpayer, then you got to find that statute unconstitutional, because in essence you're gutting it, and it's a chilling effect on the school districts throughout the Commonwealth that are struggling to have sources to fund public education if you grant the relief they request.
Thank you.
Thank you.
Oh, look at this.